Good afternoon, and welcome to the Beresford Booth weekly webinar. I'm Sherry Bosse Lueders, and I'm joined here with guest Amy Egtvet of We Trust Company. Today, we'll be talking about the benefits of nominating a professional fiduciary in estate planning documents. Very pleased and happy to have Amy joining me today. Amy is an owner and the CEO of We Trust Company, a Washington state chartered trust company that provides a range of professional fiduciary services. They serve as trustee, personal representative, attorney-in-fact for financial matters, and as family office administrator. We Trust Company has been in business since 1997 and has a reputation for being high touch, detail-oriented, and deeply caring toward their clients. Welcome, Amy. I'm so glad that you were able to join us today. If you could, please tell me a little bit about your background and your path toward becoming a professional fiduciary.
Sure. Well, thank you, Sherry, and I really appreciate the opportunity to talk to some of your clients about this matter. I guess I did not set out as a little girl to become a professional fiduciary. I don't think I even really knew what that term was until well into my 30s. My background is in small business administration and nonprofit administration. That's kind of what I did out of college with a history degree. And I was very comfortable with numbers, with budgets, with balancing budgets and implementing systems. But I lost my father at a fairly young age in my late 20s. And I saw the incredible amount of work involved in settling an estate. And so I was very intrigued by that process. And soon after his passing, I actually met my business partner, Sherry Ware, who founded We Trust Company. She had a background as a paralegal for many years in estate planning and probate and recognized that there was a need beyond what paralegals do so well in sort of high-touch servicing of certain clients, really helping them navigate the probate process. And so I was intrigued by that. She had been sort of doing her professional fiduciary practice for about 5 years when I met her. We formed a partnership and started out with really helping navigate probates. And that eventually evolved into the 4 lines of business that we have today that we'll talk about.
Great, thanks so much. And I also have another big picture question about We Trust. One of the things in your bio mentions that We Trust is a Washington chartered trust company. Can you talk a little bit about what it means to be a chartered trust company?
Sure. We did not start out as a chartered trust company. We were just 2 women who formed a business and had a partnership and practice in this space. We went through a rather arduous process. It was almost a 2-year vetting process with the state of Washington back in between 2014 and 2016 to be chartered as a trust company. And what that means is you sort of open your whole book in your life to the Department of Financial Institutions, which is the regulatory body in the state of Washington for both banks that are chartered in the state and trust companies. And they look at things and decide whether you are legitimately a trust company. And they gave us powers back in the beginning of 2016. And since then, we have submitted to an exam every 18 months. The Department of Financial Institution comes in and examines our books, makes sure we are dotting our I's and crossing our T's and doing what we say we're going to do for clients. And so overall, I feel like it was a great step for us as a company. It has professionalized us, and we work very closely with the DFI to implement whatever recommendations they make once they've reviewed us.
Thank you. That's very helpful. And I'm going to put my list of questions up here. I'm hoping that this can be a little bit more of a conversation. But if you could speak a little bit about just the basics of what is a professional fiduciary and what is it that you do?
Right. It's a term that gets thrown around a lot. There's a lot of, there's advertisements on TV for financial advisors that are fiduciaries. It's kind of a big, broad word. So I'm going to read two different definitions that I found that I think really embody what I think is a professional fiduciary. The first one comes from the Seattle Estate Planning Council, and it's very basic, but it's just core to what we do day in and day out for people. And they write, a fiduciary is someone trusted to manage property for a beneficiary. A fiduciary, so a beneficiary we can get into later. There's lots of different types of beneficiaries, but we're trusted to manage property for someone else. A fiduciary is expected to be thoroughly honest, careful, and act with undivided loyalty to a beneficiary. So we really have to get ourselves out of the equation and think and act on the best, for the best behalf of the beneficiary of these funds, these assets, these properties. The second, so that's a great sort of cut and dry answer to what a professional fiduciary is. The second definition that I found that I thought was like, this really helps define how We Trust approaches this work is from the Professional Fiduciary Association of California. And they go on to say, a fiduciary's role is not merely that of a business manager, a decision maker, or a guardian. It's also a nurturing bond of trust, concern, and attentive caregiving. And I think we really try to approach each of our clients that way. A fiduciary seeks to support mental and emotional well-being, reduces stress of changing circumstances or unexpected events, and most importantly, helps each client and their family enjoy a full life. So that's very aspirational, but it's what we try to do in this work every day.
Yeah, it's interesting. Two very different perspectives on what a professional fiduciary is.
Yeah, but I tell people it's sort of, it's both numbers and mechanics, and there's a huge heart component to what we do as well, and a lot of psychology of listening to family members and understanding family dynamics as we step into the roles that we serve in for people.
Absolutely. So let's talk a little bit about those roles. You mentioned in your intro the various roles that you do fill as a fiduciary at We Trust. I was wondering if you could speak a little bit more specifically about what those various roles look like for a professional fiduciary.
Sure, absolutely. So We Trust has evolved again from those early days of really just helping navigate probates. We've evolved into 4 lines of business is how we define them. And when I talk about the 4 lines of business, I like to use an airplane analogy that I will use throughout. But the 4 lines, they go, we still do that personal representative role that started the company so many years ago. So we're written into documents, into wills. And when the time comes, our job as the personal representative is to marshal all assets of a decedent, of someone who's passed, pay their final taxes, file any estate tax returns that are required, and distribute the assets of the decedent per their will. So they give us the instruction, they tell us what they want to have done, and we do it. In this role, with the plane analogy, I feel like we are flying the plane and we're landing the plane to a logical conclusion. And sometimes that can take a short amount of time. Oftentimes it takes 2 to 4 years to settle estates. It really depends on the complexity. The second line of business that we have, sorry, Sherry, did you have a question?
Oh no, I was about to jump in and continue on your analogy. It's sometimes with the probate, there can be some midair refueling
Yes,
as
absolutely.
it continues on. It's one of those things that takes as long as it needs to take.
Yes, and no probate is, they are similar and yet very different than each other always. So there's always something new there. The second line of business that we do at We Trust is we serve as trustees. Obviously, it's in our name. We're written into trust documents, either testamentary trust that occurs after someone passes away, or Maybe they want to set up a trust for someone in their family while they're still alive, and we can serve as the third-party independent trustee. In this case, the trust document is very much our guide of what we can and cannot do, but trust documents are very open to interpretation. There's lots of room for interpreting it differently. So it's really important that we build a strong rapport with the beneficiaries of the trust and the grantors, if possible, the people that set the trust up. If they're still alive, we have conversations with them. If they're not, you can imagine we have to sort of read the document and hope that we understand what they were attempting to do. In this role, the analogy of the plane is that we are flying the plane. The beneficiary is one of the passengers. We care about them and we talk to them regularly, but we are flying that plane. In our third different role as a fiduciary, we serve as attorney in fact under durable power of attorney. And I know you're going to talk about that in a little bit, Sherry, but this document comes into play when someone is still alive, but for some reason or another, they either cannot or will not manage their own financial affairs anymore. In this role, we're the co-pilot in the plane. This document requires their involvement to the degree that they can be involved, and we really try to meet people where they're at. Someone may be having cognitive decline, but they may still have very strong opinions about how their money is spent and what they want to have happen with it. So we really try to walk alongside them or fly that plane with them. In attorney in fact roles, there are definitely bumps, but we try to smooth out the plane ride and make sure that it goes very smoothly. Last but not least, and I know we'll talk more about attorney in fact, but last but not least, our firm also serves as a family office administrator. And this is not a traditional or standard fiduciary role, although we treat it very much like all of our other appointments. For a family office administrator, we're engaged through a letter of engagement, not a legal document. And we do a myriad of daily money management tasks for people. So they're busy, busy folks who maybe just don't want to spend their Sunday night managing their households. So we do a lot of bill pay and organization and communication for them. In this role, again, back to the plane analogy, they are flying the plane. They are in charge. We are merely the flight attendant that tries to make it a comfortable and smooth ride for them. So those are our 4 lines of business.
Thank you. And, I am going to switch gears and talk a little bit about the professional fiduciary as power of attorney, the agent under power of attorney document, where you are acting as more of a co-pilot with someone who's still very much alive and perhaps can participate to some degree in whatever management of their finances or affairs that you're doing. And, when I talk with professional fiduciaries in my practice, they will almost invariably ask my clients to have those powers of attorney be effective immediately if they're nominating a professional in particular. And I'd like to have you speak a little bit, Amy, about why that is and why it's so important when an individual is nominating a professional fiduciary for that power of attorney to be effective immediately.
Right. Well, I guess I would start off by saying I believe, in 22 years into this work, this is hands down the most powerful document that your clients will sign. Because again, it is only effective when they are still alive, and they have to have a huge level of trust and faith in the person that they're appointing, whether it be a professional or a family member. And so in my experience over the years, springing powers of attorney or powers of attorney that are not effective immediately cause all manner of mayhem when you need them to be in action. So let's say someone has either has some sort of catastrophic situation where they need a power of attorney immediately, or more often than not, what they have is a slow cognitive decline. It is very tricky to have doctors sign letters that say, I deem my client no longer capable of taking care of their own affairs. That is a very, very challenging bar or threshold to meet. And so having the powers of attorney effective immediately, while that is perhaps a scary proposition for some of your clients, I can tell you, I can assure you that as a professional fiduciary, we have zero interest in getting involved in someone's business until it's required or necessary. So even though your client might sign an effective immediate document, doesn't mean that we trust is going to come in with guns blazing and say, we're taking over your life. What it does allow for is when the document is needed to come into play, if it is ever needed to come into play, we can step right in. We can walk alongside. We can bring calm to a situation much more quickly than we can if we have to run around and get approvals from doctors. And one other thing I'll say about it, and I hope I can say this in a way that makes sense to people. If you don't trust the person that you put in a power of attorney to stay out of your business when you're competent, when you're capable, if you don't trust them, then you should not put them in any power of attorney, springing or not. Does that make sense?
Oh, that makes a lot of sense.
High
And
level,
that's
yeah.
that's some very good advice there, because it's absolutely true. It's yeah, you can't trust the person not to act in the power of attorney when you want them to, and at the right time. They probably shouldn't be nominated in that role. And that's, one reason why I think I do have clients that turn to professional fiduciaries rather than people in their lives, for making those nominations.
Correct. Yes. And that's in large part why we exist, is for those, wanting to keep family members, and third party professionals we're neutral advocates for our clients.
Yeah, yeah, that's a nice characterization. I also wanted to talk a little bit about co-fiduciary. So co-fiduciary is when there's a co-trustee of a trust, or a co-agent in a durable power of attorney, or a co-personal representative, where there's two or possibly more than two, but even just two individuals who are both fulfilling the same fiduciary role. I think sometimes people, even when thinking about appointing a professional fiduciary, will think in terms of co-trustees or co-personal representatives in order to have a family member possibly watch over the professional trustee, or perhaps having the professional watch over the family member's management of affairs. Amy, can you talk a little bit from your perspective on some of the pitfalls in the practice of nominating co-fiduciaries?
Sure. I'll tell you out of the gate that we made a decision probably 3 or 4 years ago not to accept co-fiduciary appointments anymore, which is a pretty hard line in the sand. But the times that we have served as co-fiduciary, bottom line is, it, in my opinion, and this is my opinion, it needlessly complicates what already can be complicated matters to administer. Even if you write it in a way where co-trustees or co-personal representatives can act independently of one another, I'll tell you, as a practice, even if we could act independently from a family member, we're not going to do that, because we're going to cover ourselves by making sure that they agree with us on the decisions that we make. We've tried things where we've had people sign over sort of all of the administrative rights to us, and they, so that they're serving as co-trustee, but really, and they have a right to sort of to fire us if they want to, which is absolutely something I always advocate for. But then they just can't help themselves but end up in sort of all the decision making with us. Where I have found that people want to put co-trustees together is often they don't want to offend family members. They might not want to offend their oldest child by naming their second oldest child as the trustee of something and not having the oldest child involved. Some of our best appointments as a professional fiduciary have been where we were brought in as the solution to fighting co-fiduciaries in a family. So, brother and sister are named as co-PR, they can't get along, they lawyer up, they end up hiring We Trust to just navigate it for them. So it's not my favorite thing. I think it's fraught with peril. I think it needlessly complicates situations. And I think there are other tools available to attorneys and to clients to make sure you still have that oversight of a professional trustee or professional fiduciary. Things like trust committees or trust protectors are things I absolutely advocate attorneys write into documents to make sure that there is a mechanism to remove a professional fiduciary if you do not like how they are administering the matter.
Yeah, that's a very good point. And that's, I think, outside the scope of our conversation, but there's so many options in drafting trusts for the ability for beneficiaries to have a way to, some way to facilitate a beneficiary to seek removal of the trustee or to have a trust protector in there so that there's somebody who's keeping watch over the third party. I think that can help a lot of people sleep easier knowing that that's there.
I think so, yeah.
And then, just to kind of wrap things up here, do you have any big picture advice for folks when they're doing their estate planning and thinking about making their fiduciary nominations?
Absolutely. I would say, just do your research, do a lot of research. All of the professional companies in town have people that can answer questions for you. So make phone calls. If you don't get phone calls back from them, that kind of speaks volumes to whether they're available to service you. And you're entrusting your lifetime, if you're writing a will, you're entrusting your hard-earned money into hands of other people. And I think whether that's a family member or a professional, you really need to be very thoughtful about that decision making. One thing I encourage people all the time to do, and I don't know how you would feel about this, Sherry, but is to write side letters if they're going to set up a trust for a child. A side letter is not a legal document, but in a side letter you can write from your heart about what you hope your legacy will be with this. And for a professional trustee, those are very helpful for us to interpret what a grantor would like to have happen with a trust. Again, they're not legal binding documents, but they're helpful guides for us.
Lastly, I'm going to jump in and say that's actually really gratifying that you said that, because I do like to tell my clients when they have additional instructions that are a little outside the scope of the legal documents, I do encourage them to think about having, I like how you call it a side letter. I call it an informal document or a guidance document, something they keep with the original documents that's more about values and guidance and less about the legal structure of what's happening with these documents.
Yeah, always helpful. Lastly, I always talk, if I get an opportunity to talk to clients while they're in the midst of estate planning, I will remind them that inheritance, in my opinion, inheritance is a privilege. It's not a right. And they should do good planning with good practitioners like yourself, and then go out and enjoy their lives and enjoy their own money and not sit in the dark so that their child can inherit, more money. I think it's a wonderful thing to leave a legacy for your children, and it's also important to live your own life.
Absolutely. And I think that's where the planning part of estate planning comes in a way.
For sure.
But I do want to thank you for your time this afternoon, Amy. This has been really educational and fun for me. I've had that last slide up on the screen for a few minutes now. It's got Amy's contact information and my contact information. If anyone out in the audience has any questions for either of us, I'm happy to talk with you. Otherwise, thank you again for joining us for the Beresford Booth weekly webinar.